is a very contentious divorce, Your Honor. I keep getting cut off, Your Honor, and I don't want my words misconstrued, and that's what's happening here. I'm advocating for my client, so I don't want. I feel like I'm getting beaten up on here.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties engage in mediation with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Allison Fulmar, representing the plaintiff, Michael Yunch Jr. Mr. Yench Jr. appears to be present. In addition, Attorney Kirsten Nimmich is present, representing the defendant, Robin Yench. Ms. Yench appears to be present. That was an awful quick mediation. Started at 8:30, it says 9 o'clock. Have the parties reached their own agreement resolution this morning, Ms. Fulmar?
No, we haven't, Your Honor. In the interim from the last mediation that we had, I've spoken with Ms. Nimmich on a couple of occasions. We've exchanged emails back and forth. We've talked. We've spoken with respect to the details of the property and its equitable distribution. Mrs. Nimmich sent me an email indicating that I believe that, and I'm trying to find the exact wording, that it was her client's final, what she would accept. And it was a list of what she would accept, and that was it. I presented that to my client as a final offer. We reviewed it in detail several times. There's a rational legal basis for his refusal of that. And so therefore, we have no other option than to ask for a trial before this honorable court to determine the equitable distribution of the marital assets.
Well, it must be significant assets. We're talking about a 3-year marriage. I don't think the court's ever had a trial over a 3-year marriage. So have you discussed with maybe separate rooms to discuss with Mr. Walker? Maybe he can help the parties find some middle ground. I mean, there's no one side. This is absolute and take or leave it. I mean, the purpose of mediation is to discuss, to find some middle road resolution.
Your Honor, may I respond?
Please, go ahead, Ms. Nimmich.
I sent Ms. Fulmar an email on July 2nd. At no point in that email did I say it was a final offer. I would invite her to read it very carefully. It listed 18 items. 4 of the items differentiated or differed from what was offered at the prior mediation. She sent me, when I followed up asking for a response because I had not received a response, actually I take it back, her response had gone into my junk folder. So when we did speak again, we had a lengthy phone conversation. It looks like it was on July 17th, wherein I walked Ms. Fulmar through the offer and pointed out to her that there were only 4 items of difference. And one of them was not even a piece of marital property. It was a gift. So I didn't really feel that we were very far apart. I did indicate to Ms. Fulmar that I expected a response from her client, that perhaps there was some wiggle room, that I expected a counteroffer. I have never once said to Ms. Fulmar that I would not mediate, I would not negotiate. However, Ms. Fulmar showed up this morning and basically refused to engage in mediation after being invited by me multiple times and Mr. Walker multiple times to engage in mediation. We are literally a few items apart in what Your Honor correctly pointed out is a 3-year marriage. There are no children here to fight about. This is only property.
Your Honor, I'm not going to sit here and let Ms. Nimmich incorrectly state. Now, if we have a recording.
All right, hold on right there, Ms. Fulmar. The court's can order the parties continue their discussion with Mr. Walker this morning. Mr. Walker, if you've separated him in rooms, do that. If in fact we need a trial date, you're gonna the best resolution is one in which the parties participate. Mr. Yench, if we have a trial, what's going to happen is most likely the court's going to liquidate everything. That's what happens in divorce trials. We liquidate things and we divide cash, whether it's personal property, real property, retirement benefits. We're gonna do that. So your best interests are served by participating, because you lose control when you go to trial. The court decides all these matters. So there should be some good faith discussion this morning. Mr. Walker, keep in separate rooms if they need to be. If they need to be separated rather than 4-party. I'm not sure you conduct, Mr. Walker. I'll leave that to you, but again, it's been 30 minutes. There should be some good faith discussion this morning. If you can't, then I'll give you a trial date and we'll have a real quick trial date. So
Your Honor,
with that,
may
the
I
court should,
please, Your Honor, may I please
sorry?
respond? Mr. Walker, I told Mr. Walker, my client does not want to go to trial, but because
Okay.
but I keep getting cut off, Your Honor, and I don't want my words misconstrued, and that's what's happening here. Mr. Walker indicated you don't need to say anything else. So if I can't talk on behalf of my client and advocate and express our position, then I keep getting cut. If you want a trial date, then we'll get a trial date. That's what Mr. Walker said, and that's why we're here, because he would not allow me to speak when we were in the breakout room.
I'll take exception to that, Mr. Fulmar. Mr. Walker has been a very capable mediator with this court for years.
I didn't say he wasn't. I just said
Your Honor, may I defend myself for a second?
I said my client does not want to go to trial. But this is where and then he said, if you're saying you want a trial date, I said, may I explain? He said, there's nothing more for you to say. And I feel, Judge, that if I can't express what I'm saying, then it frustrates the purpose of what we're trying to do. That's all I'm saying. I didn't say he was not capable. I did not say he was not effective in your honorable courtroom for years. I did not say that. I'm saying what was just said to me. And if that's recorded, that's what it would show. I just, as an advocate, as a lawyer of 25 years, I just like to be able to say what I need to say for my client. That's all.
Absolutely. Absolutely. And I'm sure Mr. Walker is allowing you to do that, Ms. Fulmer. Mr. Walker, do you have any suggestions? Should we just set for trial?
I'm not sure what to do at this point. Ms. Fulmar did come into the mediation and multiple times stated that this case had to go to trial. She said that specifically. It was multiple times. At that point, I'm not going to say she refused to mediate, but she did say that this had to go to trial. She did not want to waste everybody's time. That is exactly what she said. So that's why I contacted your secretary and had them come in here.
And Your Honor, to follow up on that, I asked.
All right, we're wasting everyone's time. These parties are paying their lawyers. Ms. Fulmer, do you want a trial date then?
Judge, you just ordered us to go back into mediation.
I know, but what I'm hearing now is that you do not want to mediate this morning. Ms. Fulmer, I'm not going to force you to. If you don't want to discuss resolutions matter, we will give you a quick trial date. Do you want to continue discussions?
Judge, I'm going to follow what you suggest and recommend.
Okay, all right.
I don't know why everybody's trying to make like I'm the obstinate one here. My client wants to resolve the matter. Let that be on the record. My client wants to, we can go back into mediation. I don't want to do what is futile. I told them, I said, I'm at the American Bar Association, and that's why I was late coming in. I'm here trying to learn things to practice better. And I had spoken to my client for the record, and my client indicated instead of, and Mr. Yench, you correct me, I'm advocating for my client. So I feel like I'm getting beaten up on here because my client, he does have a right to a trial. When my client, and I go over things with my client, and he feels as though these offers are not in his financial best interest, and he says he wants a trial, I'm going to ask for a trial. Did you not indicate to me, Mr. Yench?
Ms. Fulmer, I have just one question. Do you want a trial date this morning?
I want to do what the court has ordered me to do, and we're
Ms. Fulmer, I'm not going to order you to continue mediation if, in fact, your client wants a trial date. I just have one question. Do you want this matter set for trial this morning?
No, we'll go back to mediation, Your Honor. That's fine with me. I'm good. I'm here. We can go to mediation. We will again. We were on for what, almost 5 hours last time? I mean, but. And I've spoken with Ms. Nimmich. I think we had very productive conversation and exchange of information. At some point, sometimes you just need the court to tell the party certain things. This is a very contentious divorce, Your Honor. There are other elements in this. So I'd love to avoid a trial. The trial is going to be lengthy in and of itself. Who wants to try this case? No one. So I will go back into mediation. Absolutely. Whatever it is, we can schedule 3 more mediation days. It's fine. I want a
No, if we
resolution.
do
My
not resolve the
client
matter
wants it.
today, we will schedule for trial. So I'm gonna have the parties go back and talk to Mr. Walker. And if there's no progress being made, then the court will come back out and the court will schedule a trial date.
Yes, Your Honor.
All right, Mr. Yench, keep an open mind. This matter is being recalled subsequent to the parties continuing their mediation efforts with Mr. Walker in front of the court. Again, this hearing is being conducted via Zoom. Present is Attorney Allison Fulmar representing the plaintiff and Attorney Kirsten Nimmich representing the defendant. Both parties are present. Ms. Fulmar, have the parties been able to make progress in the last couple of hours?
Yes, Your Honor. We have what I thought was a full settlement.
I can't hear you, Allison.
We're going to turn off your video so you can hear us.
We have come to a full settlement.
Wonderful.
Praise the Lord, Judge. We were just in the process of going onto the record to place the agreement on the record. And I asked, because there's been splitting of hairs all throughout how we've done this, I just want to make sure that we don't get on the record and have a record that's convoluted with back and forth. So I asked Mr. Walker if he could bring in Ms. Nimmich so we could go over the particulars of who's awarded what. There were a few items that, and I think it's minor, but we, that apparently got lost in the translation. Ms. Nimmich, I was saying things on our end, Ms. Nimmich saying things on her end, so we didn't have an understanding. Specifically, I'm speaking about what I thought was number 9, which would be awarded to defendant wife. I had, and I read this.
So, I'm sorry, Ms. Fulmer, it's noon. My staff they have a lunch break. You need to talk further with Ms. Nimmich. So to go through I don't have the list in front of me. You go through that together. What if everyone zooms back in at 1:30?
I have a second mediation, Your Honor, at 1:30 with Mr. Walker.
Okay, so we don't have an agreement then, correct? We need to discuss some issues further.
We do have an agreement, and it would be.
Hold on, Ms. Fulmer said there's some issues regarding item number 9, and I have no idea what the list is. So do you need to discuss it further, Ms. Fulmer?
Sure, but we were brought back on the record, and that's what I was trying to do, Judge. I was just trying to clarify. I wanted the opportunity to go back to my client and say, hey, what about this?
Okay, all right, let's take a recess. How about 1:15? Ms. Nimmich, can you appear at 1:15? You and Ms. Fulmer can spend the next 45 minutes talking about these remaining issues.
Yes, Your Honor.
I'm just offering that as a suggestion. Again, it's 12 noon. Again, I can have my staff back by 1:15. We go back in the record at 1:15 if that works with everyone's schedule.
Your Honor, I think that this could be resolved. I could place the items of property that are going to be awarded to my client on the record, and all other items of property would be awarded to Mr. Yench, other than what is specifically stated on the record. And I think that would be the easiest and least convoluted way of addressing this.
I don't think that's quite how it needs to go, Your Honor. I haven't.
All right. This matter is adjourned to 1:15. If the parties, Mr. Yench, appear at 1:15 this afternoon via Zoom.
Okay.
And then Ms. Nimmich, if you and Mr. Fulmar, I don't know if you want to talk on the phone. Mr. Walker obviously has another mediation at 1:30, so he's obviously gone to lunch. So the two of you need to work through these issues together without Mr. Walker.
Understood.
Judge, that's fine. If we can stay on, can we still use that way I can call my client and just make sure that we're clear, and I'm sure we can work it out.
Yeah.
It's small things. It's just, I just heard of it.
Okay. Do you want a breakout room? Can we
Yes.
leave the breakout room open?
Yes.
Yes, we can put you in a breakout room and leave that open during the noon hour.
Your Honor, where will my client be? Are we having them stay off of
It's up to you. We'll
Ms.
put you all
Neiman,
four in the
can we
breakout
just
room
call our
so that
client? If
everyone's on the
we're
same page.
Zoom, if we're on Zoom, we can just, I'll call my client, I'll have him hang up, and then I'll just run past him what you give me.
Okay, Robin, will you be available?
Room. He's already in the breakout room. We're gonna put all the remaining three in the breakout room.
Okay, thank you, Your Honor.
You like my hairdo?
Yeah, you might want to turn off your video. I don't know
How do you turn it off?
Back on the record, Ms. Fulmar, were you and Mr. Nimmich, and I appreciate your continued efforts. Were you able to work through some of those remaining small issues? I'm sorry,
Yes.
you're muted. Oh, there are.
Well, Your Honor, and thank you very much for that opportunity and for your vision and for your patience in this regard. So at this point, we'd like to place the settlement on the record. And I know we've already put the proofs on the record, so we'd like to place the settlement on the record.
Very well. And of course, the proofs were taken back on April 19th. We simply need to update the proofs in the nature of confirming that Mr. Yench is not now pregnant. But Ms. Fulmar, do you want to state what you understand to be the agreement on the record, please?
Yes, thank you very much, Your Honor. Your Honor, parties have agreed as follows that one, that Mr. Yunch plaintiff will pay off the pontoon boat, plus he will pay the difference of whatever that balance is as of today of the pontoon boat and $20,000. He'll pay that difference to Mrs. He'll pay that difference in cash to Miss Yench. So in other words, if the pontoon boat is $19,100, which is the approximate payoff, he'll pay the $900. That's just an example. It's somewhere around that to Miss Yench within 90 days. Mrs. Yench, the defendant, is awarded the 1972 Chevy truck as is. She will be picking that truck up. Miss Yench, defendant, is awarded the pontoon boat, which is in her possession. Ms. Yench, defendant, is awarded the 66 Badger, which is in her possession. Ms. Yench is awarded the 2010 Ford Focus, which is in her possession. Ms. Yench is awarded the 2013 Ford Focus, which is in her possession. Ms. Yench is awarded, the snowblower, which, did we say, that's the one thing.
It is not currently in her possession. Is that the question you had?
Yes.
Yeah, it's not currently in her possession.
And I just need one moment, Your Honor. Mr. Yench, what about the snowblower?
She took that in September, but I don't know if the snowblower in question is the one she gave to my brother for helping her move or not. I don't know, but I'll get it back for her. She can have it.
Okay, snowblower. The Ms. Yench, defendant, will have the LS motor that she purchased. She will pick that up. Ms. Yench, defendant, will be awarded the gray and black toolbox. That was her father's, and handheld drill press, which is at Jeff's. Ms. Yench is awarded the stand-up drill press. She is awarded the radio and disc that she gave to his brother. Ms. Yench defendant is awarded the air compressors, the 2 air compressors. No, it was 1 air compressor and one vacuum, we'll say compressor. There is an electric saw. Ms. Yench is awarded an electric saw. She's awarded the organizer for the drill bit. She is awarded the 1987 Chevy R30, which is a red truck, as is. She will pick that up on Monday, 8/5, before 3:30 p.m., which is at the home of Mr. Yench, Mr. Yench's brother. She is awarded the jet ski, which is at the home of my client. We will make arrangements for that, but the defendant will make arrangements to have that moved according to how it's a big item, but she's responsible for having that moved. The plaintiff, do I have everything, Ms. Nimmich, with respect to?
No, there was the paintings.
Oh, okay, I have that here. Yes, thank you. She's awarded the paintings. Okay. The plaintiff is awarded the 95 F335, the 2018 Ford Focus, 2013 Ford Fiesta, 1973 Jet Boat. Sign over the title. She will sign over the title as both parties will mutually agree and sign over the titles to these items. The plaintiff husband is awarded the cigarette boat. And the defendant this defendant, okay, if these items, meaning these personal property items belonging to plaintiff husband, which are his inherited china and his photographs of sentimental value, if any of those items are in the storage unit, Ms. Yench will return them. If defendant wife is also awarded a desk that's at the former marital home, kids' bike, and a TV wall mount. If there is, if plaintiff husband has in his possession fishing supplies, parts for a pontoon, boat and badger, and teal fabric cover for boat, then he will return those items or make arrangements to have those items returned. The defendant, Mrs. Yench, shall be restored to her maiden name Baker. The parties shall keep their own bank accounts in their own names. There will be no spousal support to either party. It is forever barred. The one joint account that the parties had at Michigan First is awarded to defendant, Mrs. Yench. The parties shall each keep their pensions, etc. All other, they will retain their own debt in their name with the exception of Mr. Yench paying off the pontoon boat. All other debt that's in their names, they will be responsible for and hold the other party harmless. And all other property that is in each party's possession, they shall retain. I believe that is the total of the property settlement.
Spousal support is not awarded and forever barred as to both parties. Is that correct?
That is
correct.
yes, that is.
Any retirement benefits? Are they each going to keep their own?
Yes.
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 Right.
Your Honor,
Right.
and
Thank you.
I'm sorry, it's just one other thing. If Ms. Yench discovers that there is a Honda mini bike in her possession, she will return that.
Thank you, Ms. Fulmar. Ms. Nimmich, did Ms. Fulmar accurately state your client's agreement?
There are a couple of clarifications and additions. So each party is going to be responsible for their own attorney fees. And then when it comes to property, I just want to clarify a few items. It was not a silver air compressor, it was a vacuum pump. So Ms. Yench would be entitled to receive a silver vacuum pump, a red round air compressor, a handheld drill, a red belt sander instead of an electric saw, as well as a stand-up drill press. She would also be entitled to the gray and black Craftsman toolbox, as well as the Craftsman's tools, and 3 statues. It sounds like they're statues she made. One is of Donald Trump, one is a giraffe, and the other is a frog with their accompanying paints.
If I think that was if that's in his possession,
Right.
he will return it.
Okay, it wasn't mentioned at all. It's my understanding those things were in his possession. The only thing he was unsure about were the boat parts and the fabric.
Okay, I'm sorry if we missed that, but those were items that I read that if he, Mr. Yench, do you recall those being in your home?
No, they're not in my home. They were at my brother's house. That's another items that she had given away. Now I'll go collect what I can. I'll do that.
Okay, and then I needed some clarification. I thought that the truck, the 1987 red R30, was going to be at Mr. Yench's residence, but if I understood Ms. Fulmar correctly, she now intends that it would be at Mr. Yench's brother's residence along with the jet ski.
No, the jet ski is at my home. The truck is at my brother's where it's been for a year.
I understood, but I understood Ms. Fulmar to say that the jet ski was going to be moved. So I was seeking clarification on that issue. Where is Ms. Yench picking up those items from?
What I said was that the jet ski is at the home on Lily Pad, and that Mrs. Yench will pick it up from there.
Okay.
And then that the 1987 Chevy R30 red truck is at his brother's home. Is that correct, Mr. Yench?
Yes, it is.
Okay.
And that's where he's picking it up from? Because the reason I'm asking is we were told to pick it up before 3:30 because Mr. Yench wouldn't be there because he was
the truck.
Right.
The truck.
So if it's at a location that Mr. Yench doesn't live at, I'm not understanding why it needed to be before 3:30. I just want to clarify.
I don't know what you were told. Yeah, I don't know what you were told, but it's at the brother's home and she can come and pick it up there. I don't know where that extra information came from, but no, that he does not live there. She's welcome to come there. We were told she'd be there by 3:30, before 3:30, or I think you said that. And that's fine. It is at his brother's home where it's been for a year.
Okay, so do you
Who
understand
has
that,
the
Robin? Is
key?
that okay with you?
I will go to his brother's house to pick up the red truck. Yes.
Okay, good. Who has the key to the red truck?
It's in
Michael
my
does.
possession.
I'm sorry?
I do.
Okay, how are you gonna get that to your brother's home?
It's at my brother's home.
The
But
key.
the key is with the truck at my brother's house.
Okay,
Yes.
that's, you said you
Yes.
had the key. I want to know where the key to the truck is. You're saying your brother has the key and you're to the truck and your brother will be home to give Miss Yench the key this afternoon. Is that correct?
The keys
No.
are at the keys are at my brother's house. My brother will not be home until after 5. That's why I say come and get that truck before 5 p.m. so there's no interference. Before 3:30 is good because that's when I get there. The key will be with the truck in the truck. Or I can drop it off with Miss Nimmich. It doesn't matter.
All right, so Mr. Yench, you're going to be there at 3:30 and have the key to the truck, so Miss Yench can meet you there and retrieve the truck and the key.
No, Your Honor.
No, we can't do that.
Hold on. Okay, so if we do this, and Your Honor, I will say that Ms. Nimmich and I can work together to help coordinate when and how these items can get picked up. I don't know that we necessarily need to put that on the record.
Okay,
But,
all right. I just want to make sure everyone's on the same page. That's all. Ms. Nimmich, why don't you continue with any other clarifications?
I believe that was everything.
Okay.
Can we make sure he's awarded the box truck, the GMC, and I am the other red truck? I wasn't sure if I heard that.
Yes, he is awarded the GMC, the 1999 GMC.
And the LS motor not purchased by him. I guess there were 2 LS motors.
One was in the boat, so that comes with the jet boat.
Okay.
So
Understood.
again, just the LS motor that Miss Yench bought, that's what she's awarded. And my client is awarded the other LS motor. Is that correct?
It is currently in the jet boat. Yep.
Okay, all right. That will conclude the settlement, Your Honor.
All right. Thank you, Ms. Fulmar, Ms. Nimmich. Mr. and Mrs. Yench, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
All right, we've already taken the proofs. Once again, Ms. Fulmar, if you just want to confirm with Mr. Yench's understanding of this agreement.
So, Mr. Yench, you heard the settlement that was just placed on the record. Is that correct?
I did. Yes.
And do you believe that this is a fair and equitable distribution of the marital assets or the marital property,
Yes, I do.
as well as the debt?
Yes.
And you understand that you have a right to ask for a trial in this matter. Do you understand that?
I do.
And you understand also, if you ask for a trial, you could have gotten awarded more or less or come out about the same. You understand that?
I do understand that.
And having understood that, you still wish to accept and abide by the settlement with respect to distribution of the marital property.
I do.
Are you under the influence of any alcohol or drugs or anything that would impair your ability to negotiate the settlement today?
No, I am not.
Okay, and I've been representing you throughout these proceedings. Have you been satisfied with my representation?
I have been satisfied, yes.
Okay, very well. Okay, I think that's it, Your Honor.
Thank you, Ms. Fulmar. Ms. Nimmich, do you have any questions, first of all, for Mr. Yench?
Yes, Mr. Yench, have you disclosed all of your assets and liabilities during these proceedings?
I have.
I have nothing further, Your Honor.
Thank you. Questions for Ms. Yench, please, Ms. Nimmich?
Yes, Robin, can you state your name for the record?
Robin Yench.
And I just need to confirm, the last time we were here and we took proofs, you were asked if you were pregnant. I just need to ask you again, are you currently pregnant?
No, I am not.
Okay. And you heard the agreement as it was placed on the record, correct?
Yes.
Did you understand it?
Yes.
Did you have any questions about it?
No.
Did what you heard Ms. Fulmar and myself state on the record, did it accurately reflect the agreement you believe we negotiated today?
Yes.
Okay. Have you had time to think about that agreement?
Yes.
Have you had time to discuss it with me?
Yes.
Is anybody forcing you or coercing you to enter into it?
No.
Do you believe that the agreement is fair and equitable?
Yes.
And you understand that by placing it on the record today, it is now binding on you.
Correct.
That means you can't come back and ask the court to make any changes to it.
I understand.
Okay. And you understand that you could have taken this case to trial and the outcome could have been different, right?
Correct.
But rather than take the case to trial, you're asking the court to take the agreement that we've placed on the record today and make it a judgment of divorce.
Yes.
Okay. Have you disclosed all of your assets and liabilities to Mr. Yench?
Yes.
Okay. And finally, are you satisfied with my representation?
Very.
I have nothing further, Your Honor.
Thank you, Ms. Nimmich. Ms. Fulmar, do you have any questions of Ms. Yench?
No, Your Honor.
Who will prepare the judgment?
I will, Your Honor.
Thank you, Ms. Fulmar. Again, the court would like to thank and acknowledge Mr. Walker for his assistance this morning. And the court will also like to thank and acknowledge attorneys Fulmar and Nimmich for helping facilitate an amicable resolution between the parties. And the court would applaud you, Mr. and Ms. Yunch, for ultimately reaching your own agreement without question the best resolution. Keep in mind, you'll not be divorced till the court signs written judgment. Hopefully that'll be within the next 30 days. But the court applauds you for reaching your own agreement with the assistance of your very capable attorneys. Based on the testimony that's been presented today, as well as previously, the court finds again jurisdiction has been established and that there has been a breakdown of the marriage relationship. There's no chance of reconciliation. According upon receipt of the proposed judgment approved by the parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Fulmar, Ms. Nimmich. That will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor.